as a proud member of the Indian judiciary, extremely delighted to be amongst the members of this great bar on this occasion. I thank you for all the kind words, and I will say something about the suggestions later. 19 years as a judge, and still the memories of being an advocate are very fresh in my mind. I was a part of the bar for 22 years. That is more than my career as a judge. And so believe me when I say I know it all. I believe I know the problems, the concerns, the lifestyles, and also on a lighter note, the maneuvers of the bar. The strength of any institution depends on its foundations. And undoubtedly, the strength of this institution is the bar. You all do a great service to this nation by discharging your duty with dignity, determination, and utmost distinction, almost all the while. This is something which cannot really be put in words, cannot be spoken about, but I can assure you that from the bench, that great strength of certainty, that great strength of power, that great strength of assurance comes when the response of the bar is right to what falls from the bench. I, for one, have always seen that great judgments originate from great arguments. And it is often the learning of the bar which influences the course of our judgments and therefore the course of history. The relationship between the bar and bench is special, given that by all accounts the bar is the mother of the bench. After all, most judges commence their careers there and then join the judiciary. All of us, I like to think, are like co-partners of an undivided family. Anything detrimental to one of the co-partners naturally affects the others. But the more important reason for the special bond between the bar and the bench is the values and the beliefs that unite the two. It is this unity which has time and again ensured ardent adherence to the rule of law, for whose existence we all exist, for whose existence the institution exists. It is this unity which has time and again ensured the zealous protection of the basic and fundamental rights enjoyed by the citizens of this country. There have been numerous instances when the judiciary has been called upon to engage with challenges and tasks that usually others avoid to address. But we believe resolution of these matters is crucial to the shaping and continuance of a peaceful and just society. On every occasion I can say with a sense of pride, both in the past and in the present, that the judiciary has been able to meaningfully respond and in the process become the catalyst of socio-political change. But at the same time, I must acknowledge that the judiciary has been able to do so only because of the strength and support it has always derived and received from you, that is a strong and committed and resilient bar. It is the bar working together with the bench which has enabled this glorious institution to be the most willing to stand up for the values of tolerance, liberty and dignity. I did not inadvertently use the word resilient. Resilience is the only quality that helps us to adapt to change, and change is something we must be willing to initiate and accept. In fact, I have always thought that hard and brittle objects break very easily. Therefore, resilience is necessary. I do call upon this occasion for the bar to study and pay attention to the changes that are necessary and which might be initiated by the court in the years to come. There are some changes which are very necessary, and I do hope that the bar will be alive to the need for those changes and willingly accept them. Our judiciary is one that is independent, and both the bar and the bench have on many occasions zealously guarded it. At the same time, it is equally important for all of us to maintain independence and integrity of not only the judiciary but also of the bar. If the bar loses its integrity, it would have an enormous repercussion on the workings of the judiciary. As I mentioned earlier, actions of one co-partner could affect the other as well. It is our collective responsibility to ensure that the credibility of the bar is maintained, and it will be maintained only if members of the bar continue to act freely, diligently and fearlessly in promoting the legitimate interests of their clients without any fear or inhibition. A crucial aspect of this independence also involves ensuring people's access to independent and affordable advocacy, advice and assistance from lawyers. Almost in all the interviews which I have had to give upon my elevation, one question I must tell you, often asked by the media, was lawyers' fees. And I must say that I answered, we have nothing to do with it. I am speaking here on this occasion in the presence of the learned Attorney General, the President of the Bar and all of you. We have nothing to do with this, but I can assure you it is a concern of the people, and I say this because of the way the journalists question me about it. This institution belongs to the nation, and achievements are the result of unflinching dedication and commitment of the numerous individuals on and off the bench. It has been able to play a defining role in public life in large measure because of the trust it enjoys with the public. Having said that, I acknowledge that there remain areas of concerns in the working of the institution. The seating arrangements are the least of them, though they are important. That is natural, especially in an institution that attempts to balance day in and day out the firmness of the law against the vagaries of human nature. However, we must always remember that neither inadequacy nor aberrations define a system, nor are hasty solutions a sensible way forward. day in Bangalore, Justice Venkatchalaya told me something very graphically. He said, I know you will be tempted as a Chief Justice to make changes, but remember that the pace of change has to be slow. If you change the slope of a drain suddenly and steeply, the water might flow off and leave the rubbish behind. I thought that was an excellent way of putting the correct pace of change. Concerns require well thought out solutions, for hasty responses are often likely to complicate the problem. Over the last few years, through concerted and coordinated efforts, we have taken important strides in addressing existing concerns, including those of pendency of cases, infrastructure and vacancies. Given the increasing usage of information technology among the citizens, we must increasingly focus on harnessing information technology and information technology enabled services for providing more efficient and cost-effective access and delivery of justice. This must include serious study concerning the future of artificial intelligence in law, especially how artificial intelligence can assist in judicial decision making, certainly not substitute it. I believe exploring this interface would be immensely beneficial for many reasons. For instance, it would allow us to streamline courts, caseloads through enabling better court management. This would be a low-hanging fruit. On the other end of the spectrum, it will allow us to shift the judicial time from routine, simple, straightforward matters, example cases which are non-rivalrous, and apply them to more complex, intricate matters that require more human attention and involvement. Many nations of the world are taking to it, and we hope we can do it soon too. There are other aspects that need our consideration for a better legal system, and this is going to come up. Decision on matters, certain matters, by circulation, not necessarily by oral hearing. Some matters may not need oral hearing. A lot of time is spent in it. Consider imposing qualifications before appearing in superior courts. If any of you take the time to see the mentioning that happens in court number 1, you will find a lot of it is so uninformed. There is no doubt that advocates must have a right to practice in courts and in all courts. But I do believe that it is not detrimental to equality if certain qualifications are required before certain courts. One cannot seriously expect somebody, and I am not talking of the geniuses, but by and large, for a year or two, an advocate is not well fitted to address superior courts. This is something which will require some thinking. I understand that the bar associations and the bar councils are all bodies which are elected, but nonetheless, for the sake of the profession, some thinking will have to be done on such qualifications. It can be a special part of the curriculum for law students in their universities to learn the best practices in law, which are otherwise learned in the chambers of advocates, where juniors learn the art of practicing by observing their senior. I think this is an institution which is waning. We were all brought up in chambers, and we from where we could keenly observe the way our seniors think, the way our seniors speak, and the way our seniors address the court. You will be surprised that I come from a high court which has original jurisdiction, and the art of cross-examination is dying even there. The universities will have to revive it. All of this may appear to be a long-term solution. Maybe a lot of us will never see the benefits of it, but that is no reason why it should not be thought about and implemented. The only guarantee of an excellent bar in the future, this is the only guarantee of an excellent bar in the future, and therefore an excellent judiciary. Equally important in solving today's concern is developing the ability and foresight to deal with emerging problems. Everyone seems to be leading a very demanding life. Legal practitioners, including judges, face enormous pressure on the professional front. Such a demanding lifestyle can have grave consequences on the health of an individual. Apart from schemes like insurance, I believe we must no longer live in the hubris that only physical well-being is important. We can all agree that mental well-being of members of both bar and bench is equally, if not more important. I think the time is right to focus on the mental well-being of all of us, the judges and lawyers, and efforts in this direction must attempt both destigmatization of the idea and making available professional help wherever necessary. The Supreme Court Bar Association must take the lead, whether before or after the election. The Vice President and President both mentioned several things about chambers. The Learned Attorney General also joined. We'll certainly look into it. There's a committee, and I believe the chairman of the committee is with us, Justice Nageshwar Rao. The committee is entirely of judges of the Supreme Court who have been members of your bar. And the committee will go into it, we'll look into it. In the meanwhile, I would like to say that this entire case has been argued without any pleadings. It will be forgotten. I won't say anything now. We look forward to a meeting. And I must tell you in the meanwhile that there is not a division, but there is a difference in opinion between whether you should share a chamber or whether you should have a single chamber and whether you should have cabin or not. This is something that will have to be firstly resolved by the bar itself, and then a unanimous opinion be given to the members of the committee. I will say nothing about what the Learned Attorney General said about the tenure of judges. He was addressing as a member of the bar, and I can say to him as a member of the bar, please tell this to your client. We are willing to work. Finally, I thank the Supreme Court Bar Association and office bearers and members for their good wishes and for this felicitation. I must place on record the tremendous work you have done during the last year or so, and I look forward to your continuing support. Thank you. Jai Hind.
We are grateful to Honorable the Chief